Can a police officer pull over a car because it has excessively tinted windows? To find out, you have to read People versus Nektalov, but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Nektalov. The citation for this case is 2024 New York Slip Opinion 02725, published by the New York Court of Appeals on May 16th of 2024. The issue in this case is whether police have probable cause to stop a vehicle when the officer believes that the vehicle has excessive tint. To understand and appreciate the context of this case, the background that's helpful to understand is, first of all, that VTL, Vehicle and Traffic Law, Section 375, describes and defines what is an illegal tint of a window of a vehicle. It states that no person shall operate a motor vehicle upon a public highway, road, or street with windows which have a light transmission of less than 70%. So in New York, there's a 70% light transmission requirement at least. So if it's less than that, then if it's less light than that, then it's not a legal tint. And the second thing you have to know is that in New York, there's a probable cause hearing that's allowed after an arrest and prosecution. During the suppression hearings, one of the things that a defendant can seek and obtain is a hearing as to whether the police had probable cause to stop a vehicle. And at that hearing, the people have the burden to come forward with proof, evidence sufficient to show that the stop was lawful. Summary statements that the police arrived at a conclusion are not sufficient. You have to show at that hearing, the prosecution must establish the basis, the factual basis, to believe that the police had a right to stop, had probable cause to stop the vehicle in the form of facts, not just conclusions. So what are the facts in this case? The facts are that in 2018, Detective Fortunato and his partner were observing a car driving down the street with excessively tinted windows traveling down a public road. So the detective pulls over the vehicle. The defendant in this case, the defendant Nektalov, is actually a passenger of the vehicle. The detective pulled over the vehicle, and when the detective approached the vehicle, he saw marijuana in plain view, which was illegal at that time. It's not illegal at this time to have some amount of marijuana, but at that time it was. They arrested and searched the defendant and found 2 bags containing cocaine, which is also illegal then and now. The defendant moved to suppress the drugs, arguing the police lacked probable cause. They had the probable cause hearing, and at that probable cause hearing, Detective Fortunato testified about his observations. But what he said was that he observed the windows of the vehicle and observed that they were excessively tinted windows. That's the extent of what he testified about, that the windows were excessively tinted. The court denied suppression. The defendant then pled guilty, and the defendant appealed his conviction, claiming that the suppression hearing was wrong, that the stop was bad. The appellate term, upon appeal, held the testimony was sufficient, and the detective had probable cause to stop the vehicle because of an apparent violation of VTL 375. It goes to the Court of Appeals, and here, the holding is that the testimony was insufficient to satisfy the probable cause hearing. Why? Because the detective did not testify why the windows were excessively tinted. Or in fact, whether they were legal. To say they were excessively tinted is sort of it's a subjective determination that the windows are excessively tinted. Were they 71%? Were they 69%? It matters legally. He didn't say, for example, as other cases have had, where the stop has been allowed or the stop has been held to be sufficient, that the windows were so dark he couldn't see inside. That was from the case of People versus Biggs. He didn't say, for example, that he had specific education, training, and experience to identify whether the windows were legal or not legal under 375. He didn't measure the windows with using a tintometer that could measure the amount of tint of a window. All he gave was his conclusory statement that it was excessively tinted and no facts to support that conclusion. And therefore, the stop was determined to be insufficient. It was not based upon probable cause, and the evidence recovered therefrom should have been suppressed. And the case is therefore, the accusatory instrument, the complaint is therefore dismissed. Case closed. That's the case of People versus Nektalov. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.